This class will deal with the cessation of employment, ways in which employment can end. It's a large topic, so we've broken the class into two parts: cessation of employment 1 and cessation of employment 2. This is number 2, and it'll look at some ways in which employment can be terminated. The first one we'll deal with in this session is constructive dismissal. Now, this type of dismissal occurs when an employer decides to terminate a contract of employment because the employer no longer wishes to be bound by the conditions of the contract. This is quite a unilateral decision. The employer decides that he or she simply does not want that worker for whatever reason and decides to terminate the contract on that basis. In these circumstances, an employee may be forced to resign. In other words, the employer, having decided that he or she no longer wants that worker, that employee, that then make circumstances such that the employee is forced to resign. The employee no longer feels comfortable or wanted or respected in the job and is therefore forced to resign. If an employee has been dismissed, they have a right to bring action against the employer on the grounds of unfair dismissal. So depending on how the employee was forced to leave, they may be able to bring an action against the employer for unfair dismissal. Now, constructive dismissal. Well, in order for an employee to be considered for unfair dismissal, the employee must prove certain things. So in order for an action to come against an employer for unfair dismissal, the employee must prove certain things. They must show that the employer has committed a breach of contract. The employer broke the contract of employment, broke the terms of the contract, and therefore it was unfair. The employee was forced to resign against his or her will. In other words, the employer brought pressure to bear on the employee and forced the employee to resign. Now, reasons for resigning. Well, there has been a breach of the employee contract, as I said earlier. That may be one reason for resigning. The contract has been breached. The person is no longer doing the job for which they were contracted. Their condition of employment has changed. The employer has changed it radically. It could be that the employee is being underpaid or has been demoted for no good reason. The employee would have to show, if they were going to bring an action against the employer, that they were demoted and there was no reason why they were demoted. It was just an unfair act. The employee has been forced to accept unreasonable working conditions. So, for example, the terms of the working agreement has been changed, and has been changed to the detriment of the employee. Perhaps the employee is now expected to work outside, whereas before they were working inside. Or perhaps they are now required to work longer hours, or to work on Saturdays, or they're expected to work under noisy conditions, and perhaps the work has been changed radically in a way designed to get them out of the company. The employer has found ways of making the employee feel unwanted, uncomfortable, not respected, and is trying to force the employee out. It could be also, in quite an extreme case, that the employee has been put into dangerous working conditions, or has been asked to relocate, move to a different plant, perhaps a long way from the original one, so there'll be extra travel, or changes in the working hours, as I mentioned earlier. These are all ways in which the employer could try and put pressure on the employee And of course it could be actual physical or verbal abuse from the employee or from other employees, from the employer or from the other employees. So if it's verbal or physical abuse, then the person is being bullied. The person feels intimidated. And leaving is really the only option. But that's unfair. So it's constructive dismissal. There would be an action against the employer for doing that. That is unfair. In order for employers to avoid accusations of unfair dismissal, now for the employers to avoid accusations of unfair dismissal, they must make a job position redundant. If a person leaves or has been asked to leave, it must be that there is no job. In other words, that position is no longer required. So that's a defence. A defence was the person was asked to leave, the employee was asked to leave because there was no job. That job is redundant. And the employer must provide adequate support for the employees. It must help the employees, not just simply try to get rid of them. It must provide sufficient notice of redundancy. It just can't say, well, by the end of the week you're out. It should really give some chance for the person to find another job. It's their livelihood. They depend on it to live on it. They may be supporting a family. So it's only fair that they have a chance to find another job. So give them a long period of notice if possible. And give support and regular updates of progress. So they should be given support in finding a job, be given references, honest, decent references, which adequately provide the information that a new employer would require, that fills out the questions that a new employer would want to ask about that employee. And give the person regular updates about progress, about the redundancy. Is it still going ahead, and is there any possibility it will not go ahead? Keep the person up to date. And try to find alternatives within the company, if possible. Try to redeploy the person, to send the person to do a different task. It's a different job, but at least the person's got a job. They've got an income. So try to find alternatives if possible. Or even relocate the person. Get them position in a new plant, or in a different plant, in a different area. So if the employer is making all of this effort, then that's a defence against constructive dismissal. Of course, the employer would give redundancy benefits, redundancy pay to the worker, and that partially diffuses the situation, because they are giving the employee some income, some money, which will see them over while they try and find a replacement job. They may be able to provide training or some sort of advice to the employee as how to get a job and where to look, and try to emphasize their skills and help them with their CV, and get professionals in to give some career advice and some direction. So the employer is making every effort to support the person, and if that's the case, they can't be accused of constructive dismissal, of trying to simply get rid of the person, because they're making every effort to try and help the person. Now, there are invalid reasons for dismissal. For example, if a worker's away from work for a while because of injury, because of sickness, and as a consequence the employer tries to get rid of that person, then that's not valid. It's not a good reason. And that would be construed as constructive dismissal. They're trying to get rid of a person simply because the person was away ill. Well, humans do get ill from time to time. We get coughs and colds and sprains and we hurt ourselves and so on. So people do go off work for some period. That's understandable. Lodging a complaint against another employee due to physical, verbal abuse or harassment. If a person lodges a complaint against another employee, that should be investigated. It doesn't mean that the person lodging the complaint should be sacked, should be dismissed. It should be investigated. So if there is a dispute between employees and one is bullying the other, the person making the case should not be dismissed. Instead, the case should be investigated. So an employer who gets rid of someone just because they complain, that's not right. And of course, there's always the problems about race and gender, age, ethnic origin, disability, marital status, maternity leave, religion, personal circumstances. People may be asked to leave for various reasons. So these are based on prejudice. And these are all invalid. This is not the reason why people should lose their jobs. They should not lose their job because they belong to a particular ethnic origin or because they have a certain disability. If they can do the job, that's it. The case is made that this person should have the job because they can do it. It doesn't matter about their marital status or about their religion or about their appearance or how they dress. Providing they can do the job, that's what's important. Now the employee rights, well, an employee has the right to make a claim against their employer if they feel their dismissal was unfair. So the employees can make a claim if they feel that they have been wrongly dismissed. Claims are considered and resolved in an employment tribunal. Employers must dismiss employees taking into account the Employment Rights Act of 1996. This is a UK act which gives workers some rights. They must not be dismissed on the grounds of discrimination stated under the Equality Act of 2010. So people can't lose their jobs because of discrimination, because of prejudice. That's held to be wrong. So the employers must be dismissed in accordance with the Employment Act of 1996. Now, unfair dismissal. Well, unfair dismissal occurs when an employee feels their dismissal was harsh or unjust or unreasonable. When an employee feels that, then there is a case here to examine, a case for unfair dismissal. An employee may make an unfair dismissal claim only if they have been in service for longer than 1 year. That's the law. So unfair dismissal only kicks in after a year. They can only claim unfair dismissal after a year of working for the company. An employee is entitled to compensation or reinstatement if they have been unfairly dismissed. So having made a claim for unfair dismissal, he would go to a tribunal, be examined by a tribunal, and they would issue compensation or reinstatement if they felt that the claim was correct, that they were unfairly dismissed. Now, wrongful dismissal occurs when an employer breaches a term in an employment contract. So in this case, the employer breaches a term in the employment contract. Laying off an employee without giving sufficient notice is deemed as wrongful dismissal. So asking an employee to leave, say by the end of the week, when the contract states they should be given a month's notice, that's wrongful dismissal. The contract has been broken. In effect, the employer is obliged to compensate the employee for any loss of wages, damages due to the dismissal. So if it's wrongful dismissal, the employer must compensate for the wrongdoing. So if the employer does not adhere to the terms of the contract, then that's a case of wrongful dismissal. And wrongful dismissal is heard in common law courts, generally speaking, again in an industrial tribunal, and assessed by experts in the area of employment law. So these are ways in which employment may be terminated. And see, these are some of the issues that we encounter when we look at the end of employment. It's important that you go across this video and the Cessation of Employment 1 video. Stop the videos from time to time, make your own notes, and do some research in the area, and make sure you understand the difference between constructive dismissal, wrongful dismissal, unfair dismissal, and so on and so on. So make sure you're familiar with the various terms, what they mean, and the differences between them. That's all I'm going to do in this session, so I'm going to leave it at that and say thank you for watching.